Welcome to the second part of In Touch Crime Beat. I'm Officer Don. Ray is out, so we get to be with Mary Houlihan today, which you are much more attractive than Ray Larson.
Thank you.
Listen, Ray's a good-looking guy. Don't get me wrong, but it's the glasses. Aren't they cool?
Absolutely.
But
won't let him go.
It's nice to get a break and get to talk to you. Last week we talked about this case involving Patricia Hacker, who is the caregiver that was charged with caring for someone who's mentally challenged. And she had a funny way of doing this. She basically took this poor girl to a strip club and signed her up as a dancer because the girl said she wanted to learn a dance, but of course she didn't mean that way. And really took advantage of the situation. And I understand that Patricia Hacker has now been sentenced. Is that correct?
She has been. She was sentenced to 5 years and was sent to serve by the jail. By the judge. He was so outraged by her taking advantage of such a vulnerable situation and a vulnerable adult, and just felt like there was no way he could consider probation and give her that privilege in the face of what she had done.
Well, that's good, and because we worry about that a little bit, because most of the times, most people are getting probated now. That's how it
sure
works.
Feels like it, absolutely. And one of the upsides of the case was actually I was in court for the sentencing, and you could tell very clearly that the defendant had no plans to go to jail. She was very surprised by the judge's decision, and seeing that surprise was somewhat gratifying, not because that's how certain I felt about the outcome, but because we do see so much probation, and as victim advocates have to then explain that to victims, why these choices are made, why it didn't mean the judge didn't think that a crime was perpetrated against them, why just
Their
a lot
excuses,
of bad
stuff.
news.
Well, and of course they hear on the news that they're letting people out of jail, they're not sending people to jail. They get that message, and they're like, well, they're not going to put me in jail. The jails are too full or whatever. Now the thing is, I don't want to be a buzzkiller here, but we'll see if she gets shock probation before this is over with, or we'll see if she does her 5 years, because I believe that since this technically it's not considered a violent crime to sign this person up to be a stripper at a nightclub who is mentally challenged and really doesn't understand what they're doing. And she went beyond that. She even arranged for this person to have sex with people. That's not considered a violent crime to do that.
Exactly.
So the bottom line is she's looking at maybe serving 15 to 20% if we're lucky. And she still could get that good old shock probation. So we'll see what happens to Patricia Hacker, and I promise we'll keep up with that and let you know what the judge decides to do, or what the system decides to do to this person who's committed this horrendous crime. Now, Mary, you are with the Commonwealth Attorney's Office. You are a victim's advocate, correct?
I am.
Tell us about your job.
Well, like I said, I guess sometimes it feels like a lot of my job as a victim advocate is to relay bad news to crime victims. What tends to happen to all of us is that until you're exposed to the criminal justice system, you don't quite realize what you're getting into. You have more of the TV version of how it's going to work, and then a crime happens to you, and unfortunately you quite quickly realize that the real life version is very much different, very much longer, very much more full of the defendant's rights, not the victim's. And that could become disheartening very easily, except for my attraction to the position is because I feel like if a situation is that bad, anything that I can do to make it more bearable for the crime victim is kind of where I put my focus.
And you talk about it being all about the defendant. One thing that we touched on last week that sort of stuck in my head is, and I didn't realize this, if someone's family member is killed, murdered, raped, if that person is watching the trial of the defendant and that person cries or breaks down, they're kicked out of the courtroom. Correct? I mean, you're not allowed to even show emotion for your loved one in that courtroom. They don't want the jury to see that. So you will be removed. And you're the one that has to break the news to them and say, listen, you're going to sit through this trial, but you can't show any emotion. How crazy is that?
It sounds absolutely crazy, and I'm glad you're even bringing it up, just because I do think the general public needs to realize that this is, I think they have the news version of the crime that happened, and then think about if that's covered by the news as court coverage, they're just probably assuming that a lot of things are being done to help the victim's family that just aren't in place. So what we do have, thankfully now, and this is only a change since the 80s, is victims advocates that can at least prepare the family by letting them know these things in advance, by letting them know what law applies to some things that seem so cruel as telling a murder victim's family that they can't cry in the courtroom when they see autopsy photos of their lost loved one. But if at least you prepare them in advance, then you can tell them things like, if you feel the emotions coming on, just let me know, we'll walk out, we'll take a break.
Do they remove the defendant if he starts to cry? Have you ever seen that?
Somehow, I've never seen that, never heard that as a warning, never seen any such thing. If the defendant did something threatening in the courtroom, I've seen that had to be addressed.
Sure. But if they're trying to get the sympathy of the jury. And that's the point, because I do like to get both sides of the thing. I mean, here's the reality. The reason that they don't want family members or people crying in the courtroom is because they want the jury to base the case on the facts, is what they want. And they don't want the jury to be swayed by those emotions. But I think it's insulting to those of us on the jury, because, look, I've got enough sense to know that if the evidence is there, then I'm going to convict the person. If it's not, it doesn't matter who's crying in the courtroom. You can still have sympathy for the family, but understand it does the family no good to convict someone that didn't do the crime. The jurors are smarter than that. They insult us in the public who sit on these juries by basically having the gall to tell us, you're not smart enough to detach yourself from that. You don't have the ethics to detach yourself from that. I mean, that's what they're saying.
I agree.
It's very insulting. Yes, you got to have a sense of reasonableness to things. If you've got a family member that is totally lost it and disrupting the courtroom, not over there silently sobbing, trying to hold back, okay, that's you can't have a disruption. But to tell them you can't show emotion, that just infuriates me.
It really, really does. And I think really you really hit on it with the juries. I wish I could spend more time talking to juries after some really serious cases. Occasionally, just the people that are kicked off, the alternates that kind of don't have to make that final decision. If the case has been serious enough, they'll be waiting in the hallway. They look like they need therapy themselves for being part of what the whole process exposes you to in regard to the criminal case. But at that point, I can then talk to them and then to hear some of the feedback that they have when they find out that the defendant had a criminal record, which is another thing the jury cannot know and can be a mistrial if they find out.
What you mean by that is you can have a guy that has raped 3 women in the past and been convicted, and now you could be putting that person on trial for raping another person, and the jury cannot know that he has raped before and been convicted until the end of his trial and the sentencing.
One of the things that we are trying to do in regard to dealing with some of the outrages that crime victims experience is to develop a place where crime victims can speak out about their experiences. And we're coming up with something called Crime Care. It's crimecare.org. And we're starting with developing an emergency fund for crime victims' needs that are currently not met within our community. We hope to do many more things with us as we grow, with Crime Care as we grow, but we'll keep you informed.
Okay, well, actually, we have a little more time than I thought. So you don't have your website up yet?
We do have our website up yet. So far, it's exactly one page, begging for your donations, but we hope to add a victim's voice, a blog for victims of crime to talk about their experiences, to be safe in letting their outrage be known and not necessarily directly connected to anything that would put them or their case at risk. We hope to also, in our biggest dreams, we look at MAD as a good example of how you take what happened to one person in one community and you make it into a force that helps the entire country, and MAD really is global now.
That's right. It's Mothers Against Drunk Driving, and they've had more of an impact on making the roads safer here in this country than any other organization.
Absolutely.
That started off with one mother who was outraged and was going to do something about it, and that we hope that this program grows into that, and we will make sure people stay up to date. More criminal justice news and views at lexingtonprosecutor.com. We will see you next week on In Touch.
Tune in to the following stations every Sunday to hear In Touch with Ray the DA and Officer Don. We hope you enjoyed the show. Stay tuned in for next week's episode.